Please. Katie. All persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone. Welcome to the Appeals Court. I am Justice Rubin. To my right, Justice Hand. To my left, Justice Smith. We will be hearing, I'm going to call it 5 cases today, because it is. We'll be hearing 5 cases today. The rules are as they always are. 15 minutes per side and no rebuttal. We do have a little housekeeping, though. Are counsel for both cases, the first 2 cases, all up here? Yes. All right, so the first 2 cases are co-defendants. So each side is entitled, of course, to 15 minutes, and the Commonwealth is entitled to 30 minutes. What would you think about, since so many of the issues overlap, making it sort of 20 minutes, and each of you will go for 10, and if you need more, of course, we'll give it to you? Does that work for you all?
That'll be fine for the Commonwealth.
Okay, and yes?
That's fine with Mr. Cicero.
Sorry, we're going to proceed 10 minutes for each defendant and 20 minutes for the Commonwealth, Your Honor?
That's the idea. I mean, of course, each of you is entitled to 15 minutes if you want them, but...
I think we can do it in 10.
All right. Then we will hear our first case, which is number 24617, Commonwealth versus Cicero. And I should say to all the lawyers here, we've read your briefs with some care. We're familiar with the facts, so it might make sense to get straight into your argument, although, of course, it is your time, and you may do with it as you will. So with that, we will hear first from Attorney DeMaio.
Thank you. Christopher DeMaio for Christian Cicero. I'll start with the sufficiency argument first. Those are always tough arguments, but in this case I would suggest the evidence is thin enough that it's actually at issue here. Nobody saw Christian Cicero hit anyone, or at least they didn't testify that they saw that. So we're dealing with a joint venture theory. I think all the parties agree. The judge correctly instructed the jury that mere presence isn't enough, so the question is what else was there in addition to mere presence that would get you to be able to infer intent, to shared intent to assault and batter. I would suggest there's just not enough there. Certainly, Cicero was in the bar, and he was apparently aware of this exchange of words that happened between Giselle Ligon and Mr. Billingsley. But it's not clear how much, the record really isn't developed about whether they were conferring with each other or talking to each other, what happened. What we do know is that around closing time at about 2 a.m., one of the off-duty officers who was sort of sitting apart, Jose Diaz, abruptly left when he heard that people were lingering outside and headed out into the dark. And the 2 important things about Jose Diaz are, one, he was drunk. There was testimony that he was drunk before he even showed up at the Nathan Bills. And 2, he appears to have a gun, at least that everyone said that. And when you look at the video, he appears to have a sidearm. So he sort of gets up abruptly and ominously heads out in the dark. Billingsley heads out a moment later, and he's the one who had the exchange of words. And then Christian Cicero and his brother and various other off-duty officers go out over the next couple of minutes. So
they go out more close together than the next couple of minutes, don't they? Doesn't Mr. Cicero leave essentially contemporaneously with Mr. Billingsley?
Yeah, he's in the first group when you see them walk past the video. That's fair enough. Although it seems pretty clear from the way both sides described the fight, that they were gathered up. It's not as if the first 2 guys got and started throwing punches. So what can you infer an intent to beat people up from this? Now it's possible, but I would suggest that it's not really clear what was going to happen here. This was I think as Judge McDonough said, and I'm not saying his finding has any estoppel effect, but I think he accurately described it as a spontaneous and combustible situation or something like that. So I can see it could have, seems to me quite plausible that it could have ended peacefully. It could have been a, you know, are we good, kind of a manly, we're cool, and everyone walks off. Or it could have ended like it did with a fight, or it could have gone very wrong, I guess, and Jose Diaz could have shot somebody. And then,
if they wanted it to just end, why did they walk after this group instead of getting in their cars and going home? It was already over.
well, as I said, Diaz went out first. Okay, I'm by no means saying that everyone behaved well here, that this was a smart thing to do.
That's not my question. I just said
Yeah.
they all went after. They went down to this group. The initial encounter was over. Why did they have to do that except to have a fight?
I would suggest that it's just as possible that people are going out to see what Diaz is up to as he goes stalking off into the dark with his gun, and what Billingsley, who seemed to be worked up about this, was doing, running off into the dark. Now,
He pulled his
Now,
gun,
should he have
right?
said, "Stop"?
Diaz pulled his gun and
Yes,
pointed
he
it
pulled
at
his gun.
someone.
He did.
Did a whole bunch of people from this group, including your client, push him away, press his arm down, stand in front of him, do
Yes,
anything?
there's evidence that it's right in the record. Someone said, "Put the gun down, Jose," and he put the gun
Someone
down.
did say that. Do you know who?
We don't know
Okay.
who. Okay, so that I would suggest is a decent reason to go out. I won't say it's a great reason to go out, because probably, yes, they should have called the uniformed officers instead of everyone barging out into the dark. But the question is, can you infer from these various scenarios that could have happened that when Christian Cicero went out, he was going out with the shared intent to fight? I would suggest you can't. The cases the Commonwealth cites, it's just a lot clearer. The motive is a lot clearer. The McGrath case, it's like two people who charge a guy and throw him on the ground and are kicking him. The motive is clear. I guess the best case they have is Longo. But even there, in the Longo case, it's the joint venturer had been beat up, and he said, "I'm going to get that guy." And Longo is following him around all day as he goes to get a knife. And so it was kind of clear that was going to end very badly. Whereas here, there's certainly a possibility it was going to end badly, but there are other options for how it could have ended. And it's not exactly clear that you can infer beyond a reasonable doubt.
Attorney DeMeo, I don't want you to use all of your time on the sufficiency argument, but in the light most favorable to the Commonwealth, couldn't the jury look also at the evidence about your client's belief that he had injured his foot on the same night as some evidence of his participation in this fight?
Sure. I mean, yes, I think under the Farnsworth case, you get to include stuff even if it's wrongly. But from our perspective, I mean, according to the 911 caller, once the fight got going, there was all around melee and people were punching and hitting. So from our perspective, I guess it's the people who don't have a self-defense are whoever, if it was a police officer who threw the first punch, which I have to assume under Lattimore, he doesn't have self-defense, and all the people who are there who had shared intent, who are his co-venturers. But if they weren't, then I don't know that it's that surprising that someone punched or kicked someone, because it sounds like everyone, once this broke out and all hell broke loose, everyone was doing that. I'll talk quickly. I'm down to 3 minutes. I wouldn't have agreed to 10 if I knew how quickly this would go.
You can keep going. We're not going to stop you at 10.
The complaints. So we think it was improper that Cumbie got to shore up his testimony, in court testimony, that he had been attacked by talking about what he had said to the police and how he had to go back and forth to the police station to make these complaints, and he'd been stonewalled, and how he persevered. You don't get to, it was just hearsay, and it wasn't subject to any excuse that I can see. There was never a claim that he recently contrived this, because he's been consistent, Cumbie and all the others, from the beginning. there's reference to identification. It was not an identification within the meaning of the mass guide to evidence exception. He didn't identify anyone, he said.
You're saying it's a hearsay problem? Did you raise a hearsay objection? I thought it was a 403 kind of prejudicial outweighing probative.
Well, it is that too, because the reason, when it comes in, I mean, this case had been severed from, the fight group had been severed from the so-called cover-up group for precisely this reason, because our guys, my client didn't have anything to do with the cover-up if there was a cover-up, and this makes them look bad. So it's certainly a 403 issue. It has no probative value, I guess, is what I'm saying, that he said the same.
Well, it doesn't have no probative value, I wouldn't think. I mean, I understand it has arguable probative value or something like that, but one might say people who started a fight usually don't go again and again to report it. I mean, I can't say, right, it's arguable, but I mean, in terms of like relevance, it's...
Yeah, it seems a minimal relevance. It seems highly prejudicial to me. It is hearsay, it's a fair point. I don't know if Attorney Herbert said the word hearsay, but I'm just throwing that out there because...
How did it come in?
Judge Mason said it was identification.
No, but who testified to the events of the reporting?
I think it was Cumby, and maybe also Giselle.
And they described their own conduct, or?
Yeah, I went to the police station, I sat there, I wanted to talk with the sergeant, he didn't come out, I sat 2 hours.
Well, that's not hearsay so far, that's just fact.
Well, all right, but I told him that I wanted to complain about getting jumped. Getting jumped was the word he used by officers. You're right, some of it was conduct, but there was a lot of, the gist of it was the verbal part. We were jumped by off-duty police officers, and we heard his travails of how I had to keep going back and forth. I know Attorney Miles is going to talk about the self-defense training. I would just submit the self-defense training to the extent there's no duty, and I think the government is going to agree that there is no duty for off-duty officers to use this training. It was irrelevant. It's confusing to the jury to hear irrelevant information and then be told, well, but you're not to infer he had a duty to use it, but just so you know, he did have these skills and he could have peacefully brought this to a close. It's not clear at all as a factual matter that he could have, Van Zandt is the sergeant who testified at length about this, and he agreed that the fact that you have a day of training, and my client had literally 1 day of training. He'd been out of the academy for less than a year, so he had 7 hours of training. It's training about on-duty officers with cuffs and batons. I think in the appendix you'll find the syllabus.
Did you cross-examine the witness about those limitations of the value of the training in a street?
Sure, that was done. That was done.
Okay.
But the point is, if there's no duty to use it, why is it coming in? And I guess the other point is, what is a juror to think when they hear, you hear all about this? It goes on and on for 100 pages, and the judge says, well, you're not to infer he had any duty to use this, but you should just know that he had these abilities. And this was a big part of the Commonwealth's case, I know. In their brief, they say, well, it was sort of peripheral, but this was argued at length on motions in limine. Van Zandt went on for 100 pages of testimony. It was argued in the closing argument. Somebody objected. The judge overruled him, so it sort of put the imprimatur of the judge on this argument. It was a big deal, and I would submit it was just, it was irrelevant. And it was really unfair. These are, if it had been me, if it had been any of us and we had gone to 1 day of like karate or jujitsu, it's probably not going to come in. This was put in.
Well, they're police officers.
Sure.
Presumably they use this training all the time when they confront suspects. I mean, you can say it's 1 day of training, but, I assume, I have no idea if we have any facts about what each of these officers did, but if you're dealing with suspects, presumably you have to de-escalate situations maybe more than once a day.
That may be, but again, so that's assuming you have a duty to use this here. So if there's no duty to use this, I don't understand why this comes in. And then as a factual matter, it's not clear to me. I mean, and as you pointed out, some of this did come out in cross, but this training is for people who have radios and can call for backup and do all these things. And the testimony was that they're getting in a street fight in the dark in the middle of the night. It's not clear at all that this applies, and I don't know why this much of the trial was devoted to it. I would submit it was error.
But wasn't there also evidence that there was a gun involved and or a taser?
Yeah, the gun, I think, was Diaz. I don't actually understand. Somebody did say something about a taser. That's true. But that would be Diaz. I don't think there was no testimony that anyone other than Diaz had a weapon. Diaz was said to have a baton, a taser, and a gun, so he was a
Even if that
walking
is
arsenal.
somewhere in the mix of this joint venture operation, why does that not bring the training a little bit closer than what you suggest as the sharp delineation between on-duty in uniform with police equipment and off-duty recreational?
Because my guy, Christian Cicero, who's like 5'9" and weighs 150 pounds, didn't have any of that stuff. So the question is, what was he supposed to do? And we're not arguing Lattimore anymore, so it's not, I'm saying it happened like he said it happened, which is they were walking away and they got attacked. It's not clear to me at all, and I don't think there's any evidence anywhere in the Van Zandt testimony that what he learned in his one day of training and maybe on his day-to-day work on the beat for a few months is going to help him to non-violently subdue these big guys who are suddenly punching him. It's just well. I'm already over, but I know Ms. Miles will have more to say.
I mean, you're not exactly over.
I wanted to say one, actually, if I have my last minute, it's not the biggest issue, but the judge at the end stopped defense counsel from referring to this as a bar fight or a street fight, and it literally was at least a bar dispute that spilled out in the street and became a street fight. And I would submit that was very unfair. This case was this was tried as a big case, right?
And what's the big deal?
The big deal is this case.
What does street fight or bar fight tell the jurors? That's what I'm trying to figure out. You clearly care about having been able to say that. The judge clearly thought you can't say that.
Yes.
What do I don't.
Because street fight and bar fight if this gets back to, it's a volatile situation with drunk guys. Okay, so that's, and who of us can say who threw the first punch? Who can say beyond a reasonable?
Are street fights legal now?
Street fights are not legal.
Are bar fights legal?
They are not legal.
Well, why are you arguing to them that it was a bar fight or a street fight?
Because, as I just said,
it's just a fight, right, in terms of the law.
It's a volatile situation. It was evolving quickly. It was spontaneous. Who can say beyond a reasonable doubt who threw the first punch?
And the word street fight means you can't tell, but the word fight, you should be able to sort it out. I just don't understand the value of these phrases to the defense.
Judge Mason seemed to think that it had value. I mean, that's why he made the ruling he did, and I think it has sort of semantic value. It was not, and it only makes sense in contrast to the Commonwealth's case, right? The Commonwealth's case was a big case of white policemen who were preying on black civilian people. It was covered up. It was corruption all the way up. It was a 3-week trial. There were FBI agents. Attorney Herbert was just trying to say, no, it wasn't that. This was people behaving stupidly. They were drunk. It was a bar fight. Who started it? Who knows? You can't tell beyond a reasonable doubt. It was a perfectly fair argument.
Your time has expired. I think we understand the argument, though. Thank you very much. And we will hear next from Attorney Cohen. I apologize at the beginning for confusing which table was defense and which was the Commonwealth.
Good morning. May it please the court. Jared Cohen on behalf of the Commonwealth, and sitting with me at council table is Dean Mazzoni, who is one of the trial prosecutors. I will also start with the sufficiency argument. This is a case where 4 victims were attacked. 3 of the 4 victims testified that they were assaulted by a large group of 10 to 12, perhaps as many as 15 men. I don't think there was much of any dispute at all at trial or here that Mr. Cicero was in that group of 10 to 12 to 15 men. I think the question is what actions did he take, what was his intent, and what occurred in that so-called fight. So I want to lay out some of the key evidence here, because viewing the evidence in the light most favorable to the Commonwealth, the evidence was more than sufficient for a rational juror to conclude that the defendant knowingly participated in this joint venture assault and battery of these victims with the intent required for that crime. So I'm going to pick up with fact recitation where Mr. DeMeo started as well. There's evidence that Cicero was aware of this verbal altercation between Billingsley and Joselle Ligon in the bar shortly after 1 a.m. The victims are either kicked out or asked to leave the bar. They leave the bar between 1 and 1:30. There's evidence that several of the off-duty officers, including Mr. Cicero, are outside of the bar as the victims are leaving. And at that time, Mr. Cumby, one of the victims, testified that Daniel Billingsley pushed Joselle Ligon with an extended arm, while the evidence showed that Christian Cicero was standing outside at that time. So I think the jury could have concluded that Cicero saw that. A few minutes later, the victims had called a cab. They were trying to leave. They were waiting for the cab, not in the parking lot area directly in front of the bar, but the evidence showed near the parking lot area over towards Island Pond Road. At some point, it took a while for the cab to come. At some point, the victims walked off in the direction of Island Pond Road. The evidence showed just before the cab pulled into the parking lot. Now, at that time, Michael Cintron, one of the victims, testified that he looked back, saw a bunch of men standing outside of the bar, and saw one of them wave off the cab. The evidence strongly suggests that that person was Anthony DeSantis, who was one of the off-duty officers inside the bar, because DeSantis testified that he went outside of the bar at that time, saw a cab pull up, went up and said something to the cab driver, which caused the cab driver to leave. This is also caught on the Bank of America video. It shows DeSantis leave the bar at 1:49 a.m. The cab leaves. Then DeSantis walks over to the right side of the screen, towards the Bank of America, looks off in the direction where the victims had just walked off, and walks back into the bar at 1:52 a.m. DeSantis testifies that he saw the victims there, went back inside the bar, and told his colleagues, fellow off-duty officers, hey, those black guys are still outside, essentially. And almost immediately afterwards, the first group of off-duty officers leaves the bar, walks off after the victims. The camera sees them walking past Bank of America at 1:54. So 2 minutes later, they must have left at least a minute or two before then. So at this point, you have the first group of officers, which includes Mr. Cicero, walking towards Island Pond Road, down Island Pond Road, after the victims who are walking away from this verbal altercation in the bar. You have Cicero, Daniel Billingsley, and Jeffrey Bienvenu among 3 other officers who are walking towards the victims at that point. 6 men in the first group. Bienvenu testifies that, yes, Billingsley is leading them, so to speak. He's in the lead. But crucially, Bienvenu also testifies that when they walk after the victims, they approach the group of the victims. There were two of his group who were audible, who were being vocal, and who were verbally engaging the victims. And those 2 were Dan Billingsley and Christian Cicero. Bienvenu then testifies that as they are essentially facing off with the group of the victims, at this point, there's the 6 officers who left first. 3 additional officers leave a couple minutes later in Anthony DeSantis' truck, drive around the parking lot, essentially flanking the victims and pulling up behind them. And then a third group of 2 other officers. You've got at least 11 individuals there converging on the 4 victims. And Bienvenu says that he's standing across from the group of the victims on the left side. He looks over to the right side, and the 2 officers, colleagues who he identifies as standing right there facing off against the victims are, again, Dan Billingsley and Christian Cicero. Now, at that point, the victims testified that they were attacked, that they were standing in the parking lot outside of Murphy's Pop Shop, which is about 4 to 5 business lots away down Island Pond Road from the bar, not directly outside the bar. It's at least a block away. They testified that they saw a large group of men coming after them. They heard some shouting. They turned around. They recognized the people that they had argued with in the bar, and they heard someone say, "What's up now?" They heard someone else say, "We're not satisfied with what happened in the bar. We want to settle this." I would suggest what's up now is clearly calling back to what happened earlier. I think it's clear from the evidence there that you can infer that the group, as Justice Rubin indicated, was chasing down the victims down the street, was responding to the earlier altercation, and was responding to DeSantis's conveying the information that they're still nearby. They went that way.
Okay, as I said at the outset, I think we're pretty familiar with all of the facts, and your clock is actually weird and wrong because it put all 20 of your minutes together here, and we're supposedly doing 10, although of course you can have 15 for this, for Cicero, and another for Billingsley if you need it. Could you maybe talk about the training information?
Absolutely.
That strikes me as a complicated issue.
Absolutely, and I'll try my best to stop close to 10 minutes. So the training evidence was evidence that Springfield police officers are required to complete in-service training once a year, and that Mr. Cicero, as well as Mr. Billingsley, did in fact complete that annual training. The evidence by Sergeant Van Zandt also showed that Christian Cicero completed that annual in-service training only 3 weeks before this incident.
Okay, the judge says it can't come in, and I don't know if I agree with this or any of this, but all right, the judge says it can't come in as a duty. You can't say that they had a duty to use this stuff. Presumably the only duty they have is whatever it is, to retreat or avoid physical violence if they can, or I don't know how it's phrased in the instructions. When the prosecutor says, if they had really been defending themselves, not wanting to do harm to these people, but just defending themselves, surely they would have used one of these techniques. Is that different than saying they had a duty to use one of these techniques since they knew them?
Yes, absolutely it is, Your Honor. And I just want to read the trial judge's limiting instruction. The trial judge wrote, "I do not believe the danger substantially outweighs the probative value of the capability and knowledge of the training afforded the officers. To minimize any such risk, I will provide a limiting instruction that the jury is not to consider that evidence as evidence that the defendants owed any duty to act consistent with such training at the time of the alleged assaults." And the judge gave that instruction right after, in the middle of Van Zandt's testimony. So what it's relevant to is, it is most relevant, Your Honor, to the claim of self-defense. The defendants, including Mr. Cicero, raised a claim of self-defense. They received a self-defense instruction. And in order for the Commonwealth to prove their case beyond a reasonable doubt, the Commonwealth was also required to prove beyond a reasonable doubt that the defendants did not act in self-defense, including...
I am perfectly willing to agree this can come in for something about self-defense, knowledge, whatever, capabilities. But when the closing argument is, surely they would have used one of these techniques, doesn't that invite the jury to say, like, well, if they didn't, then it wasn't self-defense? And is that any different than they had a duty to use at least one of these techniques?
Well, I think what the prosecutor argued in closing, and he certainly didn't use the word duty or argue a duty, what he argued is that the fact that they didn't use any of these defensive tactics to immobilize or incapacitate someone is relevant to the consideration of whether they used force that was excessive. And that is one of the issues that the Commonwealth could disprove self-defense on beyond a reasonable doubt, excessive force. Specifically, that the defendants used no more force than was reasonably necessary to defend themselves.
Does that change the standard to be a reasonable police officer standard versus a reasonable person standard, or a reasonable trained person standard?
No, Your Honor, it doesn't change the standard at all. It's still a reasonable person objective standard, but in any reasonable person objective standard, the jury is entitled to consider all of the facts and circumstances and take it into consideration in the totality of the circumstances to understand what a reasonable person in that situation would have seen and should have done.
Do you have a case that tells us that the facts and circumstances include what the specific training of that person is when you're looking at the reasonable person standard?
I don't have a case that makes that specific point, Your Honor, but I think there's plenty of cases that say that all of the circumstances, typically you're certainly entitled to consider, the person's size, their build, which also goes to their capability to inflict violence, which is certainly what this is.
And I assume in some cases a reasonable person with a firearm is different than a reasonable person without a firearm in terms of what they should or shouldn't do. Right? Presumably, you have to take into account some of the characteristics of the person and make it a reasonable person with some of those characteristics.
Absolutely, Your Honor, because whether a person is carrying a firearm or carrying other offensive capabilities.
Or in a wheelchair or, whatever.
Absolutely, Your Honor. And I just want to take that opportunity to answer one of Justice Hand's questions, which was whether there was evidence of a taser. Yes, there was evidence of both a taser and a baton in addition to the firearm. One of the Ligon brothers, one of the victims, testified that he was tased at some point when he was on the ground. And Michael Cintron testified that in addition to being punched and kicked on the ground, he was also struck with some type of hard object, such as a stick or baton. Now, there's not evidence to clearly indicate who was carrying those weapons, but there certainly was evidence that those weapons were in the mix as this large group of off-duty officers attacked the victims.
All right, so you can keep going if you want all the way to 5 minutes.
I'm happy to save the rest of my time, Your Honor.
Because
Thank
there's
you.
more, to come. All right, and
Thank
in
you.
fact, I'm going to give you a full 10 minutes after the next argument anyway. So we will now hear number, and so I guess that case is submitted. And we will now hear number 23-828, Commonwealth versus Billingsley. And we will hear first from Attorney Miles.
Thank you, Your Honors. Mary Miles for Appellant Daniel Billingsley. I just wanted to briefly touch on the sufficiency argument to what Attorney Cohen mentioned. DeSantis's testimony was that it was a cab driver who said he wouldn't pick up the gentleman at the end of the street. DeSantis didn't wave him off. In addition, DeSantis didn't come back and say there was African-American men waiting at the end of Island Pond Road. He just said, hey, these guys are still out there, and Jose Diaz left. Third, Billingsley was only the quote-unquote leader because he was the first out. At no point did Bienvenu in any of his testimony state that he was leading the group in this aggression to fight these men. Fourth.
Wasn't there an inference he would have been the most aggrieved based on what happened inside the bar?
Based on the testimony, what happened in the bar had been finished. All the people who were in the bar after the Cumby and Giselle and all of them had left, everything had settled. So there was nothing to be hurt or upset about at that point. All they knew was that Jose Diaz went out and these men who'd been kicked out of the bar, who had been, by all accounts, very disruptive, were hanging out at closing time, and I guess they were confused. There was no sort of agreement in this climactic moment to fight these men. And I would argue that, just very briefly, that the case and what happened out there was not quite as cut and dry as the Commonwealth would like to make it. The victims or the complainants weren't clear as to who even threw the first punch. Was it a short, bald man? Was it someone in the back of the group, or was it the taller man, Bienvenu? They're not even sure who started it, but we do know from Bienvenu that there was no joint venture to go out and hurt these men, because they told Jose Diaz to put down the gun. He put it down. Bienvenu and Cumby talked, said, we don't want to do this. This is ridiculous. They stopped. Both groups go away. And then someone made a derogatory word, and the next thing Bienvenu knows, it is the other group of men, the four men, who are rushing towards them. And that's how the melee. So all I would say at the end of this, you guys are well aware of the facts by now, is that, citing to Avery that quotes Lombard, when you're dealing with a joint venture situation where intent is important, when you have two wholly inconsistent but equally plausible depictions of the event, the government may not sustain their burden of proof because then it relies on conjecture.
Isn't there evidence that there was still a sense of tension in the bar amongst the people who remained in the police group? I think there's testimony about that.
Oh, I did not read that. From all the testimony I read, I don't remember reading that. It was that everything had been diffused and everyone was just socializing as normal.
Why did they walk down toward this group of people a block away or however far it was?
Well, I think the way Bienvenu and DeSantis describe it, it was that DeSantis went to the bathroom and then all of a sudden everyone's gone and he's like, hold on, what's going on? Then Bienvenu says, DeSantis comes in or someone says that these guys are still loitering around, and then Jose Diaz
They
left.
went down, why? Why?
Why
does this group, starting with Diaz, go and approach this other group?
Well, I can't
Everything
speak-
obviously was not over. It wasn't all peaceful. This was wholly unnecessary.
Well, I can't speak to Diaz. He wasn't part of the trial. I can
Okay.
speak to the people who did testify, Bienvenu and DeSantis, and said that Bienvenu said that they went to follow Diaz because they were concerned, and that there was these group of guys that had been kicked out. Now they're loitering again, haven't left, didn't take the taxi, haven't gotten into the car that they were in. Now they're loitering around, and Jose Diaz goes out, and they're just following him to make sure he's okay. I mean, should they have? Probably not. Absolutely not. But there wasn't some nefarious.
At some point, more than one of them starts hitting, kicking, and beating the victims. So they're presumably at that point, things are no longer peaceful between these two groups. Now, Diaz, of course, maybe he was acting on his own. He pulls out a gun. Mm-hmm. And it is true that someone says, put that away, although I don't think we know even if it's from the group that had come down second. But not wanting to kill someone in cold blood might be a little different than not wanting to have a fight with them.
Well, I think Bienvenu was clear there was someone from his group that says, hey, put that away. And yes, of course, there's a big difference between that. But then we go to Bienvenu's further testimony that says, hey, I spoke with the guy I now know as Cumbie. We discussed this. We decided this isn't going to happen. We walk away. Then someone from one of the groups, it's not quite sure, yells out a very derogatory comment. And then then Bienvenu specifically testifies that is the other group that rushes towards them, and not his group that rushes. I think that is the integral point in terms of the two wholly inconsistent versions of events. And I would say that, because this is a joint venture case, you can't really determine the intent and whether or not everyone was acting together at that climactic moment. I did want to reach on the training evidence because I think this is a really good issue. In my opinion, I don't think it matters that the defendants were claiming self-defense. Van Zandt was very clear in this testimony that this training was to be used specifically to subdue non-compliant arrestees to apply handcuffs. There is no evidence that they received self-defense training or how to de-escalate fights or how to use more force than necessary. The training was a use of force continuum on how to, without hurting people as much, without causing egregious injuries, how to subdue a non-compliant arrestee. That is not specific to the facts of this case. So, and then I would argue that the relevance is even harder to come by given the judge's limiting instruction. The judge says, you are only to consider this that the officers or the defendants have had this training. But I'm not going to tell you how to use that evidence. I'm going to tell you that they don't have a duty. So because the judge in that limiting instruction didn't give the jury kind of the contours upon which to use this evidence, it was very easy for them to use it improperly, which is what the Commonwealth asked in their closing argument. The Commonwealth specifically said, did they use any of the training according to the evidence? Maybe foot strikes to Giselle's ribs. The fact that they didn't use any of the defensive tactics, that they have all been trained in and could call upon at a moment's notice under a stressful situation tells you everything you should know about their intent. That they didn't want to just objection, incapacitate the victims, ladies and gentlemen, they wanted to hurt them. If the jury is allowed to infer that because they didn't use some sort of subduing tactics to, de-escalate, I suppose, bad word, the fight, they therefore can't claim self-defense because it shows their intent. That would, in and of itself.
You got a self-defense instruction.
Correct, but I'm saying the way that the Commonwealth.
This is just, they say, evidence suggesting that's not what was going on, or that it was excessive force. That paragraph actually begins with excessive force. Now, I know this always happens in closing argument, it's not neat paragraphs,
Correct.
So there are sentences in different places that could be interpreted differently. But it starts with excessive force. Why would they need to do whatever? I don't know. Did one of them have a broken femur or something? I don't remember.
Who are the complainants or the?
It was a violent, violent beating.
That is no doubt. There's no doubt that the complainants were injured. There's no doubt that some of the officers were injured. The fact that, this training could cause injuries, sure, but there was no evidence that any of this training specifically caused these injuries. Van Sant was clear about that. He was also clear that these weren't supposed to be used, not while on duty. And we also don't have any evidence that they could have used any of these subduing tactics to de-escalate the fight, right? We're left with pure conjecture and speculation.
Isn't that for the jury?
But if they're not given, but if the limiting instruction doesn't.
Even the closing argument said, well, maybe the kicking in the ribs, which strikes me as terribly violent, but I haven't had this training. That might be a de-escalatory tactic, right? So the jury has to sort out, could they have used any of this stuff? It can be used in some circumstances.
But then the Commonwealth says, well, because they didn't use these tactics to subdue these people, you can infer this intent. I would think, hypothetically, I receive self-defense training, right? And then I have the ability to subdue my attacker so that, he doesn't attack me. But if then I, freeze up and don't use that training, that doesn't necessarily mean that
These are police officers.
But they're off duty. Not on duty.
They suddenly, when they're off duty, they freeze up, but when they're on duty, they don't? I don't understand that.
Well, but think about it. So you're supposed to think that they follow their training, right? And their training is to be used while on duty to subdue arrestees into compliance.
But there was cross-examination on that.
Yes, but if there's no duty for the officers to act in accordance with their training, then what is the relevance? And I guess that's kind of, it seems like that's where I kind of get, hung up. And then I would argue that, given the Commonwealth's ability to put in the training evidence, and then we have this superfluous complaint to the Springfield Police Department that doesn't even involve our clients. The Commonwealth throughout the trial portrays this narrative of these rogue, trained, aggressive police officers against these civilians. But then the defense counsel, just as my co-counsel says, was prevented from arguing this is just a street fight between two civilian groups. That's basically what the street fight
Are street fights legal?
No, absolutely not. It wasn't.
So then what is the benefit? That's the other question I asked you.
Yeah, and so I would argue the benefit is that the narrative was consistent narrative, that there were these police officers who were going after these civilians, and that was Commonwealth's narrative. By not allowing the defense to argue, hey, this is a bar fight between two civilians.
Words, though, right?
What?
Just the words. It's not that point couldn't be made. It was that those particular words couldn't be used. And those are not terms of art, particularly.
No.
Even if that's the way they were being treated in the course of that somewhat heated discussion about them.
Correct.
There was no preclusion of defense counsel. Defense counsel was not precluded from arguing, hey, this was just a fight.
No,
Drunk people out of hand.
No, but I think the fact that they were precluded from saying this is just a bar fight, a street fight, because
you're defending your client and you want the jury to think it's a bar fight or a street fight. Why?
Because then it's not that it counters a narrative that there is this rogue police officer, governmental.
It's just the same crime.
But then if
defense counsel don't usually argue my client committed the crime they're charged with. In fact, that's not a good argument. Right?
No, and I agree, but I think it really goes to the issue, like, that we allow the complainants complaints to the Springfield Police Department and the on-duty training. It's like this. It's this like just. Again, I hate to use the word again, narrative that these police officers against these civilians, by kind of treating it as like this just civilian fight, helps deflate a little bit of the Commonwealth's.
Is mutual combat legal? The judge said he thought this would confuse the jury, or was a signal to the jury this was mutual combat. Is mutual combat legal in Massachusetts?
I don't believe so, but I don't know the answer to that.
I think with a boxing license,
Oh,
maybe.
yeah, I mean,
right?
something
But
like
other than that,
yeah.
I'm not familiar with people allowed to beat the crap out of each other. I don't think we have that law.
No, I don't think we do either. But I think with this, with the admission of again, I'm so sorry.
No, you're not actually. I mean, you are, but.
But again, with the admission of these guys, try to go to Springfield Police and report it 3 different times, and Springfield Police won't take it, and then there's these rogue off-duty officers. There's just this narrative that really takes away from the fact that these were just 2 disorderly groups of people that were acting inappropriately. We're not really quite sure who started the fight. We're not really quite sure who was the initial aggressor, who tried to back off, and none of it should have happened. And, which demonstrates the prejudice of the admission of this evidence. And, if there's no other questions, I rest on my brief.
So I had a question.
Sorry, Justice Smith.
That's fine. About the named victims going to the police department to report the alleged crime. What is your understanding of the judge's, the scope of his ruling for identification? Is this literal identification, like these are the people who did it, or is it the identification of the perpetrators, that they acted not in self-defense but aggressively? Do you understand the question?
Yeah, I do. So I think I think he was unclear. I think after it was admitted, it was clear that it was to be used to who was the perpetrator and who was the victim. But then I would point to the fact that this is very much akin to kind of like backdoor first complaint evidence. Not only was this evidence cumulative of the fact that they had already waited on scene and were seen by EMTs and police officers, it was always clear that they stayed and reported. That was already established. But now we've got this bolstering and this pumping up of their in-court testimony saying, hey, these guys have to be true because they went to and tried to report it 3 different times and it wasn't taken. It wasn't like there was testimony that, oh no, they reported to Springfield Police and that was it. Okay, maybe not, so no harm, no foul. But the testimony that, no, they waited for hours. They went back again and back again and back again. There's no relevance as opposed to just creating this cover-up. Which of which there's no foundation.
Your time actually has
Oh, I'm
expired,
sorry,
but
sorry.
if there are further questions, I see
Okay.
none. Thank you
Your
very
Honors.
much. We will now hear once again from Attorney Cohen.
Good morning, Jared Cohen again for the Commonwealth. I just have about 3 or 4 points that I'd like to make in response to some of this argumentation. The first one's on excessive force and the relevance of the training evidence. Excessive force was obviously relevant for all the reasons Justice Rubin was alluding to. And as far as the injuries, in addition to the fact that one of the Legan brothers said that he was tased and that Michael Cintron said that he was hit with a hard object like a stick or a baton, as far as the injuries, I just want to clarify that Mr. Cumby did suffer a broken leg, a dislocated ankle, severed ligaments, a partially fractured skull, concussion, bruised head, split lip, and had 4 teeth knocked loose. So there was plenty of evidence that very excessive force was used against these men. And related to that point, I think it was Mr. DeMeo who asked, what is the jury to do when they're given this training evidence and they're told only to consider it in a certain way? I would suggest what the jury is to do is to follow the judge's instructions. The jury is presumed to follow the judge's instructions. I'm just going to quote briefly the instruction that the judge gave them, which was that you may not consider this evidence, meaning the training testimony by Sergeant Van Zandt, in determining whether or not the defendants owed a duty to act in a manner consistent with such training at the time of the alleged assaults. And as Justice Rubin said, that was followed by vigorous cross-examination of Sergeant Van Zandt by the defendant's trial counsel. So point number 2 has to do with withdrawal. And what I mean by that is, this gets to some earlier questioning by Justice Rubin, there's no evidence that any of the co-venturers or off-duty officers, certainly not Mr. Cicero or Mr. Billingsley, ever sought to withdraw from this joint venture to assault and batter these victims. That would be required if they're trying to say they were not part of the joint venture. It certainly would be required if they're trying to assert, as they did, a self-defense argument, because they have a duty to retreat. Part of what the Commonwealth sought to prove, and I would suggest did prove beyond a reasonable doubt, is that the defendants did not use all reasonable options to avoid physical combat, to avoid a fight here. To the contrary, they sought it out. They chased down the victims and started the physical altercation. And none of the cases, neither Avery nor any of the cases cited by Ms. Miles or Mr. DeMeo, suggest that there's anything like an explicit agreement required to develop that joint venture and that intent. What the Avery case and the other cases they cited talk about is whether there's enough facts for one of the joint venturers to have known what his other joint venturers were planning to do in that situation, whether there's enough for the jury to infer from the totality of the circumstances that the joint venturer had knowledge of what was to come and therefore infer an implicit agreement. There's no case law that requires any type of explicit, much less verbal agreement. And the next point I wanted to make has to do with the reporting, which I don't think I've gotten a chance to speak on yet. And I think the important thing to understand about the reporting is that they weren't statements. They certainly weren't hearsay statements. They were conduct. They were specifically conduct of victims reporting a crime. They were testimony by Paul Cumby and Joselle Ligon, very limited testimony, I would suggest, in line with the trial court's limiting instruction, that they had gone to the police station in the weeks following the assault. And with respect to Mr. Cumby, it was particularly relevant and probative and frankly fair, because while the Ligon brothers and Mr. Cintron had an opportunity to speak to responding officers on the night of the assault, Mr. Cumby didn't. He was knocked unconscious. He was lying on the ground unconscious when the police officers arrived, and he was being treated by paramedics. So he didn't have the opportunity to speak to any police officers that night. To his knowledge, nothing came of his cousins reporting it, so he went to the police station on his own later when he had somewhat more recovered from his injuries in order to report this crime. These are victims reporting a crime. There's no hearsay issue. The fact is that on the third time that Mr. Cumby went to the police station, he filed a written complaint, a citizen's complaint with the Springfield Police Department, but you won't find anything about that in the trial transcripts because the jury never heard anything about the citizen's complaint. It certainly wasn't admitted into evidence. Nobody read from the complaint, summarized the complaint, talked about the substantive allegations other than in a throwaway phrase characterizing it, I went to go report an assault. I went to report that I was jumped by off-duty officers. So there's nothing like a backdoor first complaint issue here.
Is there authority you can point us to that says that reporting under these circumstances suggests that the reporting party is not the aggressor or is a victim in a situation like this? I understand this is not a race to the courthouse argument. It's kind of the opposite. One party racing toward, one party racing away, arguably. But do you have some authority to point to on that issue?
You know, there's not particular authority that suggests, for example, the weight that type of evidence is supposed to be given. What we do have is the judge's ruling, both prior to trial and during the trial, saying that it was relevant in the sense that it could be considered in the mix of information that the jury had. Specifically, the jury, I think, was entitled to, and the prosecutor appropriately argued this in closing, was entitled to compare the post-assault conduct of the victims with the post-assault conduct of the perpetrators, of the defendants. The defendants did not stay and report this incident when their own colleagues, the uniformed officers, came to the scene. In fact, they were nowhere to be seen. There was evidence that certain of them, such as Officer Bienvenu, ran and hid behind cars and telephone poles. Whatever it is, the rest of the off-duty officers left the scene on their own power, either walking or running, and were nowhere to be seen when the authorities came, whereas the 4 victims stayed on the scene, recovering from their injuries, reported it, and then reported it, again, in the case of Mr. Cumby, for the first time several weeks later, whereas the off-duty officers, again, citing to the testimony of Jeffrey Bienvenu, said that they didn't even want to go to the hospital that night because he didn't want to be seen to have anything to do with this incident. So I think when you compare the post-assault conduct of the victims to the post-assault conduct of the defendants, that's where the relevance is clear. I think at minimum, the jury was entitled to consider that information in the mix.
So there was no report by anyone to the police that night?
There was. Joselle and Jackie Ligon and Michael Cintron reported to the police officers that night, and I think the uniformed officer Jeremy Rivas' testimony goes to this. They reported that they were jumped and assaulted by 10 or 15 white dudes. They were the dudes from the bar. I think they were off-duty officers in that bar. They didn't really know who had attacked them.
And not one of the off-duty officers reported, these terrible people started a fight with us.
That's correct.
You should arrest them.
That's correct. They were claiming in their self-defense arguments, in their closing arguments, they claimed that these 4 victims were the aggressors. They used the terms that they rushed their group, they charged their group, and that the officers responded in defense, never mind the fact that there were 10 to 12 to 15 officers and only 4 victims. But again, to Your Honor's point, they never reported it afterwards. They never, according to what we hear in the trial testimony, they never speak of it or report it to anyone afterwards, whereas the victims do. So I think that comparing that conduct side by side is certainly relevant. And just a couple of final points. When we go to the moment where the fight and the assault really breaks out and becomes physical, when the 2 groups are facing off against each other, and Jeffrey Bienvenu says that the 2 colleagues to his right facing off the victim group are Dan Billingsley and Christian Cicero. At this point, the victims stated that they were attacked, that they could see that the first person attacking them was the short, bald man who Joselle had argued with earlier in the bar. I think it's fair to say under all the circumstances, the evidence clearly shows that that would have been Mr. Billingsley. But again, Bienvenu says that Cicero was standing there right next to Billingsley. They were the 2 who were sort of yelling at and verbally engaging the victims as they approached them, and they were the 2 that he saw there as the fight broke out. And the words that Bienvenu used, even though his testimony is different from the victims in this regard, I would suggest the jury was certainly entitled to believe the testimony of the victims as to who struck first. But Bienvenu does say that as he looked over to that area where Cicero and Billingsley were standing, he saw what appeared to be a scrum, a fight going on. He said, quote, he saw punching, people were being punched, maybe kicked, pulled down, exactly in the area where he had just seen Cicero and Billingsley. And again, that's totally consistent, that part at least, with the victim's testimony that they were punched, kicked, thrown on the ground, and pulled down. I think the last thing I want to say, just to cover a point that I made earlier, Michael Cintron's testimony also directly stated that the person, again, the short, bald man whose description met Mr. Billingsley's, was the one who approached them and stated, we're not happy with what happened in the bar. We have to settle this. We have to settle this. So again, that supports the joint venture, supports the idea that these men chased down the people that they had argued with earlier in the bar. They were continuing a verbal altercation, and they were making a decision to escalate it into violence. And I see I'm over my time, so if there are no further questions, I'll simply ask the court to affirm the defendant's convictions.
I see none. Thank you very much. Excellent arguments by all of you. Thank you. Very helpful to us. And the second case is submitted. Our third case this morning is Hardy-Rondash versus Hardy. This is a partially impounded case, and I assume that counsel will be aware of the scope of the impoundment order. I'm guessing it's financial or child-related information, but I don't know exactly, and that you'll steer clear of it. We will hear first from Attorney Hennigan.
Good morning, Your Honors. If it may please the Court, I'm Brian Heenahan from Cates and Barlow. I'll be arguing on behalf of the appellant Cassidy Hardy. There's 6 different issues that are at play in this appeal. I'll start with the child support issue. The child support issue, the argument is that the judge made a mistake of law and violated the child support guidelines without a deviation, and perhaps accepted, after the close of evidence, a new child support guidelines that my client had no ability to respond to. The initial part of the child support order was on January 16th, 2020, and that support order was $309 per week. It was in support of the four children of the marriage, Bronte, Moxie, Ovid, and Grover, eventually was born of the marriage. There's also a 5th child, Gertrude, who's not a child of the marriage. The argument is that...
So, Counsel, you believe the judge drew from the husband's post-trial submission to reach the amount of child custody?
Well, that's what the court stated in its findings, that it adopted the child support guidelines that submitted to the court. But I had never seen those particular guidelines. The guidelines that I'm aware of was submitted on January 16th, 2000. Well, no, the guidelines were submitted August 15th, 2023 by the father for $354 per week. August 23rd, 2003 by the mother for $351 per week. And then there was one August 30th by the father for $351 per week. So at the time of trial...
Well, the proposed judgment by the father said $391.
Again, I haven't seen that. The court refers to it, but it was not...
You weren't served with the proposed order of the...
I was served with the proposed judgment.
Okay, so you saw that.
Yeah, the proposed judgment, yes, okay. Not the guidelines.
Well, the guidelines are publicly available. Have you done the calculation, concluded that the 389 or 391 is erroneous?
What I'm saying is that the 389 was not an issue at trial. We had no notice that that was going to be an argument or a proposed judgment for the amount. And setting that aside for the moment, the other thing is that the child support was raised from $309 per week to $389 per week, and that is more than 40% of my client's gross income. The judgment's 43%. In addition to having the child support raised, and the findings didn't make any mention of the 5th child, and it is a defense to an increase in child support. In our proposed findings, none of which were adopted by the court, we asked for $45 a week.
Where's that number come from?
Well, I was trying to keep the child support the way that it was instead of have it increased to the guidelines. And
so you picked a number based on a prior order rather than anything to do with the actual costs associated with the subsequent child.
The child support is not based on the cost of a child. It's not a need-based. It's not a need-based thing. It's based on the calculation of the incomes of the parties. And
I'm trying to remember. I looked briefly. The guideline says something like. I don't remember, you subtract what the guidelines would say the support for that child would be, although I have no idea what that means in this case where the child has a different father, and I don't know if it means calculate how it would be in that family if they got divorced, or I don't really understand it, but
It's one of the great mysteries, Your Honor, I have to admit, because how are you supposed to calculate a child support order for a couple that's together based on their respective
maybe
incomes?
through discovery
It
you would
creates a-
get financial information about the husband so that you could do a guidelines calculation that complied
I'm not
with-
sure what that accomplishes, because it's not a fact, it's that the people are together.
The guideline says to do something.
Well, it says to take it into account, and
I
there's a
mean, I
number
guess
of
you
ways
could
to do
add it
that.
as if it's a fifth child of the marriage, but that doesn't seem exactly fair, depending on you know what I mean? Since the actual support of that child would have nothing to do with.
So part of the thinking there, in terms of making an adjustment, would be consistent with the reasons that we have the child support guidelines, is to support the children, make sure everybody has something to take care of them. $309 per week divided by 4 children is a little over $50 a week, and then there's $45 a week, a little less left over for the fifth child. And what we were trying to accomplish is just not have it raised. In addition to the child support guidelines being raised to $389 per week, my client was stuck with doing 100% of the driving with no adjustment for the costs of that.
Had that been the plan, had that been the way the parties had handled the driving before that?
Yes, the parties had handled the driving 100% by her before that, because at the time that she was trying to change from supervised to unsupervised visits, it was the easiest way to effectuate that result, to put her in charge of it. Like I said, during the time, there was a fourth child born, eventually a fifth child born, but during the time the temporary orders were in place, nearly 3 years, my client had, on more than one occasion, requested to change that to make it a more equitable situation.
Had filed a modification request?
A motion for temporary orders.
And those had been denied?
That had been denied.
How recently had she last sought to change that?
It was, based on memory, approximately a year before the trial.
I see.
And it was part of the negotiations. That was in a partial stipulation as well.
And the GAL report which recommended changing it, that was before these motions?
Yes.
Okay.
In addition to the child support, there's her share of the uninsured medical expenses. There was an arrearage in existence because she couldn't pay the existing order due to the change in her jobs and her lack of ability to continue to be a teacher.
Also, before you move off the child
Yes.
support calculation, did your client meet their burden that they were incurring expenses for an additional child?
I don't agree there is any burden to
think there's
show
any
that there's additional expenses for a child. The guidelines increase based on the number of the children that are born, with no separate obligation to show those costs. However, my client did submit financial statements to the court and did list the expenses of diapers and some of those other things on the financial statements. So there's certainly evidence before the court of the expense. And I mean, it's actually
How much was the expense?
of the diapers or
Or whatever expenses you say were on the financial statement with respect to the fifth child?
more than $45 a week. There were
How
diapers,
much were
there was
they?
formula, there's uninsured
Were they
medical
$90
expenses.
a week?
What's that?
Were they $90 a week?
I didn't add them up.
Okay, because there are two parents actually in that household.
Correct.
And so it's not clear why we would reduce the child support here if half of for the full cost of raising the other child.
And again, it's not a dollar-for-dollar expense to pay for the
I
child.
don't know what it is. I just see
thing
the
to begin
guidelines.
with.
I don't know how to.
It's, both parents have the obligation to provide financial support for their child, and my client had no way to do that based on the order and all the things she was ordered to pay compared to her income. Again, I want to reiterate, the Section C4 of the child support guidelines prohibit the order being more than 40% of the person's gross income, because obviously that isn't going to work for anybody. I'd like to move on to the modification of the judgment. Partial judgment of divorce that was dated and submitted to the court on January 6, 2023. Parties are encouraged, and were strongly encouraged, to come up with solutions for some of the issues that were in dispute. And they did that. They signed a stipulation. They submitted it to the court. The court accepted it, and as pointed out in the brief of the appellee, stated on the record, it shall be incorporated into the court's final judgment. So those issues were all res judicata.
But they weren't res judicata until the judgment entered, were they?
Well, that's the argument, but once it's submitted and the court states on the record it's going to be res judicata, what ability does the judge have to change it without notice to the parties? I might change this thing that I already said I would enter. And what that effectively did for, against my client, is there were certain protections in the language that was agreed to, and those protections were poked holes in by the proposed judgment post-divorce. My client had no notice that this was even a possibility, and one of my points in the brief is that with a 2-day trial did not have time to cover every possible thing, particularly things that had been submitted to the court and the judge had said they would accept and incorporate into the final agreement.
Judge, when did the judge say this? Do we have in the record that the judge said, upon receiving this, I will incorporate it in the final judgment?
It's referenced in the appellee's brief on page 15, and I know it's somewhere in the record. I wouldn't be able to.
It's okay. We can
pull
look it
that
up if you've got a
particular point.
citation.
But it's agreed by both parties that that's what happened. The argument by the appellee is that until and unless the judge does it, the judge has the right to change it, and I suggest that's not true once it's accepted by the court. And the parties operated under those terms from the time it was submitted on January 6, 2023, till the judgment entered.
Could I ask this? What was the change, and I apologize if this is in your brief, but what were the changes that were made by the judge that your client contests? The addition of the word reasonable?
In one, it was the addition of the word generally. The parties will generally take their children to their activities, and the word generally was in there to avoid a complaint for contempt being filed against my client, because with 4 children, with all the activities.
How are the parties supposed to know which days they don't have to do it? That's not much of a provision generally.
Well,
if it says, but absent mutual agreement, this one will do this and that one will do that, that has some specificity to it. But should no one pick them up one day? Because generally, they have to be picked up,
No,
not mandatorily?
Of course not, of course not.
All right, so how's it supposed to
the
work
issue-
if the judge doesn't do something to eliminate the ambiguity in it? How should it work?
Well, 2 things. One is the judge had already accepted it with the ambiguity in it. 2,
Okay, but
Two-
I'm talking as a practical matter.
and I am as well, Your Honor. With 4 children of the marriage and a 5th child born, it may not always be possible for one person doing all the driving to get all of the children to all of their activities. Somebody could be sick. The car could break down. There are a number of things that could happen, and what the protection is, it prevents either party from not usually or most of the time doing what they're supposed to do, but gives them the option of not doing it in certain circumstances that come up in life. Illness would be one of them. The other thing that was taken out is there was a big dispute during the trial about expenses, and my client continually testified that the father would submit the children for camps and other things and cause expenses she didn't have the money to pay without her agreement. And so we tried to resolve that by the stipulation for partial judgment that said the parties historically did these activities. It didn't mean they were going to necessarily do them forever, that they had to agree forever. Children's interests change over time, what they want to do, their capabilities change. And what this is in part is an example of how the judges wholesale adopted whatever the husband submitted for the judgment and the findings. As I said, there's like 137 proposed findings we submitted, and none of them were adopted by the court.
None of these things, if I'm correct, were brought up to the judge. After the judgment entered, was there any effort made to alert the judge to your client's concerns about the judgment, apart from the appeal?
No, I had zero faith that the judge would do anything except punish my client. There was a very bad fact from my client. She threw something at the father. He was badly injured. And once Judge Ross came on the case instead of Judge Giordano, that was all she wanted to know about. And the findings and the judgment reflect a punishment attitude towards my client. That brings me to the next point.
Well, I have a couple questions for
Sure.
you about maybe there are points that you've already covered. So you say that it was entered as a judgment, the divorce agreement, and the other side says it was not. and I look at, I don't see a judgment. I see a docket entry which reads order, 6 days after the submission. But I don't think we have that order. It doesn't say order of judgment the way other judgments do on that docket. So do you know what that document is? Is that the document you say was the judgment that was entered?
It's the partial judgment. I believe it's referenced in.
Where is
The
the
judgment
actual
itself. I'm
order?
trying to
Because
find
it
that.
just says order in the docket sheet, which doesn't say order for partial judgment.
Oh, partial divorce agreement, and then in the hearing in the transcript, she said it would be entered as the judgment. I'm looking for the judgment
I'm
itself.
asking
which I
if a
think-
judgment entered.
I'm pretty sure the judgment itself references incorporating that stipulation for partial divorce.
It doesn't reference there being an earlier judgment. The question I'm asking is there a judgment, partial judgment, incorporating the divorce agreement prior to the final judgment here?
No.
Okay. And the other question I had one other question. But I can't see what it is right now. Oh, what was this order about not filing any motions?
The trial scheduling order prohibited either party from filing any motions in limine, any motions for further temporary orders, anything. They just put a.
But there were motions in limine that were ruled on at the beginning of trial.
Correct. The father's.
When were those filed?
The father filed them, and the judge allowed the father to file them, and the judge allowed the motions, which goes to.
Filed them right there, right when the trial started, or when?
Filed them prior to the trial starting. is
In
my
violation of an order that said not to file anything.
recollection. And also a complaint for contempt against my client as well, that the judge also allowed to
And
occur.
did you try to file anything?
No, I followed the court's order, and I objected to the filing of the motions at the
Did
time.
you
of trial.
object to the court's order?
I did
Seems
not.
like a gag order of some kind that I'm not familiar with.
I did not object to that order. I could see the writing on the wall, Your Honor.
Okay, I'm sorry.
Are there questions? There's a few things I'll just rely on my brief for, but
Okay. Your
overall, I
time has
would.
expired, so we will hear now from Attorney Pickering.
Good morning, Your Honors. Jeffrey Pickering on behalf of Appellee Carmen Rondesh. I'm here with my co-counsel, Attorney Soraya Sardi. I want to start off with an issue that was just addressed, the motions in limine. First of all, Mother filed two motions.
Can you move the mic closer?
Of course. I apologize. Mother filed two motions in limine, so the statement that her counsel just made that she didn't file any motions is completely false.
After this gag order entered?
Yes. First of all, it was not a gag order. The
Reads
trial,
like a gag order.
well, the trial scheduling order said, no further motions or complaints shall be filed while the trial is pending. However, in the same order, the judge also said, all motions in limine, motions to preclude, and any other motion normally heard by the court immediately prior to the commencement of trial and any oppositions shall be served in a timely manner and presented at least 14 days prior to trial. So the judge made it very clear that motions in limine, motion to preclude, procedural motions could have been filed prior to trial.
What does the first sentence say?
All motions in limine, motions to preclude, and any other motion normally.
Oh, the first sentence of the order. What are
No
they
further
not-
motions or complaints shall be filed while the trial is pending, including motions for permission to file. However, even given that Mother did file two motions in limine and they are in the docket, Mother filed a motion in limine to preclude testimony of late disclosed plaintiff's expert. She filed a motion in limine to exclude partial video recording obtained by father. These are docket entries 276 and 277, Record Appendix 1, page 24. So for Mother now
Judge
to...
entertain those motions?
She did not because they weren't marked properly. The judge's order in the trial scheduling order said they need to be marked prior to hearing. This judge, I know some judges will hear motions in limine at trial or at a trial conference. This judge does not. So she did not hear them because they weren't marked properly according to her order. So for Mother now to say that she didn't have the opportunity to file a motion in limine is completely false because she did file motions in limine. If I can go back to the child support. Mother is mistaken when she says that the court found that the court used father's proposed child support amount in setting the amount. That is not what the court found. The court found, quote, as to current support, the court will use the incomes listed on each party's financial statement. This is finding of fact 134. So the trial court makes clear that it applied the child support guidelines to the incomes on the financial statements, and that's how it arrived at the child support amount. The child support guidelines did dictate $391 per week. The judge deviated down $2 to $389 per week. Mother nowhere.
Judge sufficiently justified that deviation as is required?
I'm sorry, Your Honor, could you please repeat that?
You didn't appeal it.
No, we didn't appeal the child support order. We don't believe that was an error. It was a small deviation down. And I think it's notable that nowhere in appellant's brief or reply brief, this is what the child support amount should be after applying the guidelines. She says this is what a child support order was in 2020, and this is what the child support order should be based on the guidelines mother submitted, but she doesn't actually say taking the incomes listed on the party's financial statements submitted at trial and applying the guidelines, this is what the amount should be, and that is $391.
And also, I'm sorry, I interrupted your answer to Judge Smith's question, and in fact, now that I think about it, if the reasoning is inadequate, obviously the other side can appeal it. So maybe you can tell whether the judge included any reasoning for why the number was 389.
She did not include any reasoning, but I think such a small deviation, again.
Well, I don't know what that means. Why would you deviate at all?
I don't know.
Unless you were making some kind of mistake.
The judge did not state why she deviated down at all. It's a small difference. It's just $2. But again, mother is now seeking for her child support to be set based on an amount that was set in 2020 after no evidentiary hearing. This trial was the evidentiary hearing to set the child support amount. So for mother to say it should have been a stale number from 3.5 years prior is just not reasonable at this
Did your guideline calculation include compliance with the rule about afterborn children?
It did not, and that is because in this, we do not believe that applies in this situation, because the child support guidelines state that, if I can just find that page, child support guidelines state, quote, obligations to subsequent family may be used as a defense to a request to modify an order seeking an increase in the existing order, but such obligations should not be considered a reason to decrease an existing order. First of all, the order for child support that had already entered was a temporary order. There was no final order. There was no final judgment. This does not apply in this case because we're not seeking to modify a final order. We're setting a final child support number through this judgment of divorce. So there was nothing that was being modified. Second, mother is essentially seeking to use the alleged cost to her fifth child to decrease the number. So she submits that she believes the child support should be $353, and she wants to decrease that because of the obligation to her fifth child, which is not what the guidelines say. They say it should not be considered a reason to decrease. This is also stated in Morales, that you can't use an obligation to a subsequent family to decrease your child support obligation. There was also testimony at trial that mother, from her partner, who I believe she might be married to now, that he testified that he paid for things in the household on wife's behalf and that she was able to use his credit card. This was his testimony. The court found and credited this testimony. The little expenses that mother listed on her financial statement for this fifth child, she put a footnote, and this is on Record Appendix 2, page 132, that these expenses are currently being paid in part by Ben Willard, who is the father of my youngest child and resides with us. So there's very, very unclear what, if any, expenses she had relating to this fifth child. There was also testimony at trial that wife received additional income from what was listed on her financial statement. There was a footnote stating that she received $120 per week for a part-time umpire coordinator position. If we include that amount in the child support calculations, the amount that the court set is less than 40% of mother's income, if that's what her argument is. There was also testimony that mother, despite claiming that she didn't have enough money to pay child support and despite being in arrears of paying child support, there was testimony about mother doing online gambling. There were Venmo records submitted at trial showing that mother had done online gambling. So the claims about her financial situation are just not credible at this point. In terms of the partial divorce agreement, that was not entered by the court as a judgment until the final judgment of divorce. As much as mother wants to say it was not. It said it shall be incorporated. Also, by the terms of the partial divorce agreement, this is Record Appendix 1, page 44, it's stated, this partial agreement shall not be altered or modified except by an instrument in writing signed and acknowledged by Cassidy and Carmen or by order or judgment of the Suffolk County Probate and Family Court. So by the terms of this partial divorce agreement, it could be modified by the court.
Even without that term, it could be modified.
Yes, exactly. And we would also submit that the things that were modified are just so minor, and the court touched on this earlier about the generally. And if mother's claim is that she needs generally in there to avoid a complaint for contempt, well, I think the goal should be to have clear orders that the parties can follow. And if one party doesn't follow an order or a judgment, there's an avenue for them to get relief from the court.
Isn't there a notice problem? Did you ask for those changes in your proposed judgment?
We did.
You asked for them?
I believe in our proposed judgment, we submitted these changes. We submitted are minor.
Huh. And when were those submitted?
They were submitted December of 2023, I believe about 6 weeks after trial. We also submitted proposed judgments at the beginning of trial as well.
And was it in that as well?
I don't recall. I apologize, Your Honor, off the top of my head.
I'm just wondering if there was notice, timely notice, to the opposing party that she should say something if she didn't like that proposal.
Well, I will say our proposed findings were submitted prior to mother's proposed findings.
By how much?
I'd say a week or so.
Is that a scheduling thing, or you were just early and?
There was a deadline set by the court. Typically, the courts are the probate family court is very flexible with extending deadlines. The mother had filed a motion to extend the deadline, and it was ultimately
But your deadline was both at the same time?
Both at the same time. We just submitted earlier, and then mother asked for an extension, which the court did allow. I will say in terms of the transportation, again, this was something that the parties had been operating under since 2021. Mother now believes this was, quote, ill-conceived. It was impossible for her to do this. I don't know how it was impossible if...
Well, it's not really that, right? The GAL apparently said that that should be modified some. Now, according to the brief, I haven't looked at the actual testimony. She said she tried to do that, what the GAL said, but the father wouldn't agree, and so she kept abiding by the agreement.
I would also submit, Your Honor, that in consideration of what these families comprise, mother has a fifth child. Father has primary physical custody of these 4 children. He does not have a partner at home. Mother also has a partner that can help with child care.
Well,
so
none of these reasons appear in the judge's order, though. I mean, that's a possible rationale for keeping it this way, notwithstanding the GALs.
we don't believe that by failing to make a specific finding about transportation means that was done in error, especially given the fact that these parties have been operating under this transportation schedule for, at that point, about 2 years.
How far apart do the parties live?
At the time of father lives in Charlestown. At the time of trial, mother lived in Somerville. I know Methuen. There was, I apologize, Your Honor, I don't know off the top of my head exactly where mother was residing at the time of trial. There was testimony at trial that she was seeking to get a new residence. So I don't know where she is now, and I can't recall exactly where she was at the time of trial. Belmont, I believe, was the time of trial. I'd also just address the issue of the trial time. As this court knows, that a trial court has broad latitude to limit the amount of trial. There were no motions made to increase trial time. There were no objections made to the amount of trial time. There were no requests to add additional trial time. So I don't know how a trial court can give more trial time when neither party has requested additional trial time. Even when the trial was scheduled by Judge Ross in June 2023, there was no objection by mother that 2 days was too little. There was no request by mother at that time to expand the parenting, expand the trial time.
Was she prohibited from making a request?
She was not prohibited. She just didn't do it. And the Baboletto's case makes very clear that a trial judge has discretion, and if there's no request by a party to expand trial time, the judge has no way of knowing that these parties need additional time. I'd also point out that this trial finished early on the second day, so it wasn't extremely early, maybe a half hour or so, but there was additional time at the end of this trial that the parties could have used that they didn't. I'd also point out a very major thing in Mother's brief is that she doesn't dispute the custody determination by the trial court, doesn't dispute physical custody, doesn't dispute legal custody. I think that says a lot about as much as Mother believes that the judge was biased, that she was prejudiced, that she ignored evidence, that she made up findings, that she believed everything Father says and nothing that Mother said. Even all of that, the Mother still concedes that the custody determination based on the evidence was within the judge's discretion. So I would ask, what would the additional trial time be for? If the judge was within her right to make the custody determination that she did, what would Mother have needed the additional trial time for? I would also say there's the claim by Mother that the court did not weigh enough of her evidence, only weighed Father's evidence. Father submitted 11 pages of proposed findings. The court ended up issuing 23 pages, over double the amount of findings. So to say that the court adopted wholesale Father's findings when the court issued double the amount of findings that Father proposed, I believe is just not reasonable.
So I want to ask you a question about reasonable contact with the children. So you submitted an agreement or a proposed schedule which was different than the initial agreement. Is that fair to say?
Yes.
And the judge also, she adopted something else, though.
So the contact that the judge adopted was that Mother would have FaceTime contact with the children on Saturdays, Tuesdays, and Thursdays.
And that's less than what you even asked for, isn't it? Fewer contacts?
I don't recall exactly what we asked for specifically. However, Mother has parenting time every Wednesday, so she sees the children on Wednesdays, every other Monday, and every other weekend. There was never the intent for contact to happen between a party and the children on a day they had parenting time. So Mother would not get additional contact on Wednesdays. On the Mondays and the weekends, she had parenting time. So other than that, she had Saturdays, Tuesdays, and Thursdays for FaceTime, which we believe is reasonable given the circumstances.
So do you believe the judge adopted a reasonable schedule, or do you believe the judge or based on the initial agreement?
I believe, given Mother's parenting time, I think that the FaceTime calls that the judge did allow for Mother and the children was reasonable. She gets 3 additional days in addition to the parenting time that she has with the children.
But that leaves her with days where she doesn't have the children, where she can't make any contact, correct?
Yes.
And you think that might be reasonable?
I think the judge has broad discretion to decide what is reasonable in the best interest of these children, and I don't think just by fact that a party doesn't have contact with children on one specific day. Not every probate and family court issues an order or judgment where there's daily contact. It could be a few times a week, could be a weekly FaceTime call. It's not a hard and fast rule that it's every day, and we don't believe that it was unreasonable for the judge to issue an order that didn't give daily contact with the mother.
That just seems inconsistent. I mean, what you write on, I'm at Record Appendix 1 at 82, is reasonable shall generally mean not more than once during the other party's parenting time on each day. They do not have in-person parenting time.
And that is certainly something that we had submitted prior, but we believe that the schedule the judge set was also reasonable because there could be different variations of what is reasonable. We do believe that that's reasonable, and there's also, Father did not have daily contact either, based on the judge's order. So just by virtue of the fact that there wasn't daily contact between Mother and the children, even though there was significant contact outside of her parenting time, we don't believe was unreasonable and outside of the judge's discretion.
All right, your time has expired. Thank you very much, both of you. Excellent arguments. No, you can submit a letter to the clerk with the page reference. All right, we will hear next, that case is submitted. We will hear next Department of Children and Families versus Mother, number 24547. I remind the parties that this is an impounded case, and so we will not use names, references like mother, oldest child, younger children, and so on are appropriate. I am told, and you get to agree on each side about how time will be split. I am told that mother will take 10 minutes. The child that we're calling child 2 will take 5 minutes. Is that right on your side?
Yes, sir.
And that then on the other side, the department will take 8 minutes, and the 2 other children will take 7 minutes. Is that right? All right. Well, with that, then, we will hear from Attorney Fisher.
Good morning, the honorable panel. My name is Julia Fisher-Neer, and I represent the appellant mother in this matter.
Could you move the microphone toward you?
Yes, I apologize. I'm recovering from a cold. So, mother is seeking to vacate the orders terminating her rights as to the 2 younger children and the orders adjudicating her permanently unfit as to all 3 children. We argue that DCF did not clearly and convincingly show mother's unfitness was permanent in this matter, and mother believes her fitness was merely temporary.
With respect only, I gather, to the 1 child. Are you contesting the unfitness or the termination with respect to the other 2 children?
We are contesting unfitness and termination as the other 2 as well. We are contesting permanent unfitness as to all 3 children.
Okay.
This family's case is truly about 2 major issues here. First, it's about DCF's systemic and ongoing failure to provide timely and meaningful assistance to the mother, who had faced poverty, fought hazardous living conditions in public housing, and dealt with physical and mental disabilities. Secondly, DCF failed to keep the oldest child safe in foster care, exposing her to sexual assault, ongoing commercial sexual exploitation concerns, educational neglect, and did not provide her with the necessary medical and mental health care, while admitting that this child's one and only safe placement was with her mother.
Can I ask about that? So what we have in place now, correct me if I'm wrong, what we have in place now is an order of permanent custody to DCF. But allegedly, at least at the time of trial, their idea for placement was placement with the mother.
Correct.
I'm trying to figure out why that's different from currently unfit with placement with the mother. Like, what is the actual practical difference from the mother's standpoint between, my sense was that you conceded current unfitness at trial?
Yes, we did
Okay,
concede
so-
current as to the 2 younger
Okay, so I don't
children.
understand the difference between what you could get if you won on this no permanent unfitness point, and if you don't. What difference does it make whether the unfitness is, we just say it's temporary, and placement nonetheless is with mother, versus we're calling it permanent, but placement is with the mother?
Yes, Your Honor. I believe the way we see it is that mother, with permanent unfitness alone, yes, mother does have the right to review and redetermination in 6 months. That is absolutely correct. However, the burden shifts to her to prove what has changed, what circumstances have changed since the finding of unfitness. Whereas if mother is temporarily unfit, that means she's still working on her fitness. So she would not have to be in the initial spot of showing what circumstances
Would
have
the court
changed.
not have to order that the temporary custody ends and that it's the child's legal custody is returned to the mother when she's temporarily unfit? She can't just say, now I'm not, right?
No, absolutely not.
Whose burden, or does she just say they have to prove it again?
Correct.
I see.
Yes, DCF always has the burden to show mother's unfitness or the parent's unfitness. And so in the case of the older child, mother was not an unfit parent at the time of trial. That is our argument.
You did not concede current unfitness as to the oldest child, is that right?
No, we did not. We conceded as to the 2 younger children, Your Honor. Because at the end of the day, DCF's placement and intention to place the older child with the mother, and the fact that they kept doing so throughout the case, and the fact that throughout this case, everything that happened with the older child showed that the very things that DCF faulted mother for as to the older child.
Yes, I'm willing to agree that DCF is unfit, but that doesn't make mother fit.
Well,
I'm going to ask the department a lot about this because I'm sure we all are, very troubled by what's happened both in the mother's home and in DCF custody. So, and it's supposed to be care and protection, and I don't see a whole lot of protection here. That's just my personal reading of the facts.
yes, Your Honor. However, the facts really did not show that mother did anything towards the older child that would show her unfitness. She participated in services as to reunification with the older child on an ongoing basis.
She was leaving the house at age 14 and having sex with strange men. Does that suggest proper parental supervision?
Your Honor, it does not suggest proper supervision in as much as the child continued to do so in DCF custody, which meant...
I agree DCF might be unfit. But when you say there was nothing that the mother did or didn't do that affected the child, that seems incorrect.
Based on the evidence that we have in this case, mother's attempts were to help the child stay with her and to provide a stable home where the child could at least feel safe to return to. She was the only
But that's
placement.
not what a fit parent has to do.
A fit parent has to provide minimally adequate care for the child.
I agree. And is it 14-year-old leaving the house to have sex with strange men? I don't remember if it's for money or not prior to the removal. Does the parent not have an obligation to supervise a child? I mean, I have to say, having read this, the older child seems like an incredibly lovely person, incredibly kind, incredibly loving. And while under the supervision of everyone involved here, she has engaged in heartbreaking, dangerous behaviors that will have lifetime consequences, I would guess. So I'm not seeing a huge amount of fitness anywhere here, actually. I mean, I hear what you're saying. You're only appealing the permanent aspect of the order, right?
Correct.
Okay.
Yes. And as to the younger children, our argument really is about the fact that for the majority of this case, there was no work between DCF and the mother. DCF really did not provide mother with the necessary guideline on what she needed to do. So it was extremely unfair to be handed down an action plan 8 months down the road from when the children were removed, and then a month later find out that there's a notice of intent filed as to the 2 younger children. So the timeline of the case was egregious, and the whole point of developing an action plan for a family is to provide this family with an opportunity to correct things that did go wrong so that mother could reunify with the children. By the time the trial came, mother admitted she did many things that were still, she was not a perfect parent, but she was engaging in individual therapy. She was signed up for a parenting class. She was seeing the children. She was really trying to work with DCF, but it didn't. We believe that DCF's inaction made an immense impact on the requisite work that the trial court then held mother accountable for. So it was extremely unfair for the court to discuss service plans that were not even a part of this case, actually, that were part of 2017 and 2018 clinical case and court case that was actually already closed by the time this case opened. So, and furthermore, we also argue that DCF really did not help mother take into consideration her disabilities. She did have some significant mobility issues. She did have mental health disabilities. And the living conditions that this family was found in initially when this case opened, that was beyond what mother could or couldn't have done. This is public housing, and mother did what
I thought she never got the ID she needed in order to change housing. Or was that ID only needed for purposes of the school enrollment or for housing too?
So that was the question that was asked of her on the stand. Did she think she needs the ID for new housing? And she said she thinks she does.
Okay, and the judge found she did.
Yes, that's correct. The judge did. Mother did have an appointment at the time of trial.
It's been years. Right,
Was
it's been years in a house with mice in the fridge. I mean, it's
Yes, Your
terrible.
Honor, I agree with you. We also understand that we're living in a state where getting housing, especially public housing, people are in line for years to change apartments. That's the reality of it.
Okay, your time has expired, but I've dominated this.
I will rest on my brief. Thank you, Your Honor.
Thank you very much. We will hear next from Attorney Grammel.
Good morning, Your Honors. My name is Sean Grammel. I'm from Anderson and Krieger, and I represent the appellant oldest child in the case. She asks that you vacate the permanent custody decree so she can go home to her mom for good. As Your Honor noted, this is a very unique case. One of the unique aspects of the case is that everyone seems to agree that mom cared for my client the best. That was my client's position, it was her mother's position, and at the end of trial, DCF's plan was to place her home with her mother. And if Your Honors look
Have they followed that plan?
I'm sorry?
Have they followed that plan? Where is the child right now?
The child, well, that's a complicated question, Your Honor. So she is still in DCF permanent custody. Her assigned placement is a group home, but she is living with her mother.
What do you mean?
That's the information I can give you. I spoke to my client last week.
Good.
She's living with her mother, but DCF has placed her at a group home, which I'll point out is contrary to the juvenile court's decision. Finding of fact 297, even DCF acknowledged that my client does best with a trusted adult.
So has there been a change to the plan? They had their plan, I thought, that they submitted to the court was a plan for placement with the mother.
Yes,
right?
that was at the time of
Has
trial.
that been changed?
As far as I know, yes, it has. It's now a group home. That's where she is.
But you don't know
placed.
why, you don't know anything about what's happened in the court since then. Of course, she was in DYS custody at the time this ended, so I wondered if she still was or...
She is not in DYS custody, no. Your Honors, I think there's one sentence in the juvenile court's decision that I think explains why mom is the fit custodian for my client. It's in conclusion of Law 15, and the judge says all of the children in this case are in need of stable, consistent care and nurturing. I agree with that 100%. And there's only one person who has ever given my client stable, consistent care and nurturing. It's her mom.
I don't think it's been stable. I don't think it's been stable. I think there's serious problems on everyone's side here.
Yes.
And I, unless you have a citation for me, I am not familiar with keeping a child because you're the fittest if you're not fit. Now, I understand your position. She is fit, of course.
Yes.
But it's been a pretty bad scene.
So my client has had time in DCF custody. I think this is her third time. Most of her life, she has been with her mother. I think the one thing that my client needs more than anything is that stability and that consistency. And there's only one person
who will be there for her no matter what happens to her, what she does or is done to her, what she says. It is her mom. You don't get that from a social worker or in a group home. You get that from your mom. And if she has any chance to tackle all of the issues that she's going to have, which Your Honor mentioned, she needs to know where she's laying her head at night. And it can't be that she's going to be bounced across 5 different foster homes in the first 4 months, or being placed in a group home that even DCF acknowledges can't give her the right care. Her mom is the best person for her. And returning legal custody to her mom is what will ensure that she knows she's not going anywhere. Her mom will be there for her no matter what. And that's something that no one else can give her. That's what makes her not only the best custodian, but a fit custodian. Because mom can feed her and bathe her, and I understand there's concerns about her housing. It can't be that bad if DCF is placing my client back with her repeatedly.
It's bad.
Well,
housing is bad.
So I would argue, Your Honor, that there were concerns at different times when mom was living there, but not the entire time. In fact, there was a police officer who made an unannounced home visit in 2021. It's at Record Appendix Volume 3,
and was surprised at how clean the house was compared to the last time.
Who was pleasantly surprised. Yeah, so it's not that mom is incapable of taking care of the house and keeping it clean, which is the standard under care and protection.
It's infested with mice in a way that's not hygienic, to say the least.
I'm sorry, Your Honor, were you going to?
No, I was going to ask when the most recent hazmat intervention was at the apartment. Was it before or after the visit by the police that you just referenced?
That was after. But as my sister mentioned, this is a public housing complex, so mom only has so much within her control. But placing her at DCF could not place my client there if it would result in serious abuse or neglect of my client.
They haven't placed her there, apparently.
Well.
Although I don't know what that's all about.
Yeah, I mean, that's all I'd say. The record.
Can I ask you, I don't know if you know this, where has she lived since trial, like in order?
I don't know if I have the entire list, Your Honor. I know DYS.
Yes.
I believe her mother's house, and then I'm not sure where else other than that.
So was there further removal of some kind from her mother's house?
I'm not sure, Your Honor.
Okay. This is a terrible case.
I've been doing these cases a long time, Your Honor. This is
a terrible
This one struck me, too.
So we very much appreciate your argument and your representation of your client, who is the most innocent party here.
Thank you.
All right, we will hear next from Attorney Murphy.
Good morning. Lynn Murphy for the Department of Children and Families. This case presents evidence of overwhelming mental health issues with mother and oldest child. That is the crux of this case, as you've already...
You have no place to put her.
We have no... Well, we continue
What you've done, I don't even know what to say about it. I've had cases before where there's been violence in a foster home, although I raise it with DCF when I see them. In DCF's care, not you personally, in DCF's care, this child, 14-year-old child, was raped, trafficked, no supervision, all put in places that obviously couldn't stop that from happening. You would take a child away from a parent where that was the circumstance. You'd have taken them away the first day on an emergency basis. So what are we talking about here? You're supposed to offer care and protection. And it seems at least as bad in your custody as in the custody of the person who is, by hypothesis, here unfit. What is a court supposed to do?
Just what the court did in this case. These two individuals, mother and the oldest child, have significant mental health issues. The child was manifesting serious behavioral problems at the age of 4 and was put in residential care at the age of 5. These are very challenging cases for the department. We've tried a variety of different services. We've worked with the Department of Mental Health. We've worked with DYS. We have provided...
So you think you guys did a tip-top job?
I think we did everything that
Oh,
could be possible.
please.
I'm not sure what services we could have.
In a shelter in Weymouth that she ran from and was trafficked and raped? Was that a proper placement?
I don't think we put her in a shelter.
That's what the testimony is. I think that was a finding by the judge. It's a shelter.
The mother lived in shelters.
No.
The department,
I mean, I can look and you can look, and I may be mistaken. That's the way I read it, that she'd been
there
placed.
have been residential placements that the child has run from, absolutely. And we've tried foster placements, and that's basically, this is why the department continues to work with mother, because we're just trying to stabilize the child. But we put in a variety, we've reviewed this case clinically numerous times, and again, I'm not sure what else could be done here.
That's what parents say all day long. And you say, we're taking your child away from you. The parents say, I don't know what else I could have done. And I'm not saying they're right, because I don't think you're right. But they say, you know, I can't keep her from doing whatever. This is a 14-year-old girl.
Well, this is part of the problem. And I point out, Your Honor, that the mother had said on numerous occasions in 2021, and when we reunified her, I cannot take care of this older child. She needs the department. If the department was to abandon mother and child, there would be no hope. There would be no hope, and mother has had a consistent pattern of being overwhelmed, and rightfully so. This is a very challenging situation, and she has significant problems herself.
So, counsel, is it fair to say that the argument is that with custody, or with the department's goal is to be able to set a framework in hopes that it will be followed and under the belief that it is a superior framework to that the mother would impose if left to her own devices, so to speak?
Absolutely. The idea is to provide appropriate services, stabilize the family unit. We have been involved with this parent for 15 years. And again, the services, mother has gotten support consistently. And there was a period of time that mother was able to stabilize to some degree, and we would back off. But this didn't.
But your position at trial was the best place for her is at her mother's house.
Because our goal was reunification, and it remains reunification.
I don't understand that. Goal was reunification, or you were reunifying them? You were putting her right in the house then?
Goal was reunification and remains reunification, and we were trying to reunify. But mother kept saying, I can't do it. So the department, if the department wasn't there to assist and continue to have custody and monitoring, I can't even imagine. I mean, this child, I don't think anyone can control this child. So the best the department can do.
I don't know what to say about that. I don't know what the best resources are. There are things that are done for children who run away that are, I don't know what they work out in the long run, but they prevent running away. Well, there are schools, there are locked schools, right?
Well, clinically, I don't know if a locked.
I don't know anything about it, but you're DCF. I don't have to. You're supposed to. I mean, I don't know what to say. What happened to her while in your custody is just heartbreaking, terrible.
It's terrible, absolutely. I mean, and I would not argue otherwise.
All right, so why isn't she in her mother's house right now? I mean, she is in her mother's house, apparently. Why is it your position she's not supposed to be?
I didn't say that. The department's position is we are continuing to work to reunify the child with mother.
Does she have a placement in a group home right now or with her mother?
She has been in and out of group homes with her mother, with her older sister, with foster parents, the same situation.
Since trial?
Yes. It's the same pattern, unfortunately. But I will point out
We have some cases that take into account post-trial facts and remand cases. The approval here, as I understood it, was for a plan where she was going to be placed with her mother. Now, maybe there are very good reasons that didn't work out, but I have no idea. Should the judge maybe take a look again to make sure that she's getting the proper?
Well, there's permanency hearings that happen on a regular basis. Mother can go back at any time on a review and redetermination. Motions for abuse of discretion can be filed at any time.
Does she have appointed counsel if?
Child has appointed counsel, yes. And I will point out that over all those years that the department was providing services, mother or child never filed a motion questioning our services, saying we were not doing what we should do, didn't object to the permanency hearings, and did not raise the issue of services at trial, not raised at all.
I'm not talking about the services provided to the mother. I haven't mentioned those.
Well, the child as well.
I'm talking about, I understand what their arguments are. I'm talking about what is supposed to happen to a child who can't be protected by DCF. What is supposed to happen here? I mean, I don't know what to say. I mean, she has constitutional rights.
Absolutely.
You know, and forcing her into a place where she can't be protected and she's raped and trafficked at 14 is not, I don't think the government should be doing that. I mean, I don't know what should happen, but not that.
Again, clinically, the department has tried to
It's
deal
awesome
with
clinical advice. It's going great.
I don't think anyone said it's going great. The department has acknowledged the challenges in this case, and that's why we did not move to terminate mother's parental rights. We're trying to work with mother and with child to stabilize her. She's 17 at this point, and in another year, she may want to sign on with us for additional services. This
She's
is very
17 or
challenging.
she's about to turn 17?
She is 17.
Isn't her birthday in March?
I thought she was 17. Maybe I'm mistaken. I thought she was born in 2008 and that she was 17 now, but maybe I'm
I don't know. I don't know what day. I thought her birthday was
But
this
in
month.
any
But
event, when she turns 18, my
Yes,
point
of
being,
course.
she can sign on for additional services, and it's very challenging. I don't think the department and the trial court certainly didn't find here that the department did not make reasonable efforts in an attempt to deal with an extremely challenging and difficult case with two individuals who have extreme mental health issues. And I see my time has expired. If there are no further questions, I'll rest on my brief. Thank you.
I see none. Thank you. And we will hear lastly from Attorney Barrow.
Good morning. May it please the court. I'm Deborah Barrow, and I'm representing C and H, the two other children in this case. And just as an aside, I do have some hearing loss, and I do use hearing aids. So if I ask you to repeat a question with the background noise of the ventilation, that's me. And thank you in advance. So yes, I am representing these two young ladies. They are asking this court to affirm the lower court judgments, the adjudication that mother is unfit, and the decision that termination of her parental rights is in their best interest. C is 10 at this point in time. And if you look at the record, you know that she spent about 50% of her young life in the care of others. She was in DCF custody from the moment she was born until she was 3 years old, keeping in mind that this was a foster placement that ripened into a pre-adoptive placement that subsequently was changed when C returned home to her mother's care, well, for the first time to meet her mother after the 3 years, so about 2017. C has been in DCF custody now since February of 2022. In between, with mother, she had periods where she was with the paternal grandmother, the maternal grandmother, unsupervised by mother, not visited by mother, where Christmas came and went without time spent with mother. And the story is not different for H, who is 9. And when she was born, and as you've read, she weighed 1.43 pounds. She's an extremely premature baby. But she survived all of that. She was placed in DCF custody immediately. She eventually was living with C in that foster home placement that also became a pre-adoptive placement until a decision was made to return H to her mother's care. This was after about 15 months when H went back to mother's care. But again, for H2, in February of 2022, she is now in DCF custody. And what I can say is that these kids are doing well.
Are they in the same placements they were in at the time of trial?
No.
Are they together?
No.
Are they in pre-adoptive placements?
No.
Is one of them where they were before?
No.
Okay, go on.
There's not a lot of information about C and H when they were younger. There's not a lot of information about the periods of time when they spent with their paternal grandmothers and the two grandmothers, excuse me. But the evidence suggests that when they did stay with the grandmothers, the maternal grandmother hit them, mother did not visit them. By the time they were in DCF custody in February of 2022, they had extreme dental issues necessitating tooth extractions and root canals and crowns and fillings. And as importantly, if not more so, they couldn't read and they couldn't write. Because
Am I correct that there was findings made by the judge that the oldest child essentially had assumed a caretaking role for the younger children for a portion of the time that they all lived together?
There's evidence on the record that the oldest child was taking on those parenting responsibilities. I think those came through primarily in some 51A reports when there were neighbors that were calling and suggesting abuse and neglect and referenced that. And I believe that was some of the other reports that, yes, that they were the suggestion of that. But yes, these young ladies, they couldn't read. And H couldn't even recognize her own name, like the 4 letters in her name at that point in time. So there, I know you've read the transcript and you've read all the evidence, and you know that when they lived with their mother, that their lives included stopped up sinks and plugged up toilets and dead mice in the refrigerator, mold in the dishwasher, and visits from the Board of Health hazmat team to address some of the issues in the home. Just combine that with their rotting teeth and their inability to read, and this is what they knew.
Was there evidence about what this substance was that the second child, I think, consumed that led her to be unresponsive at some point in the mother's care?
Correct. So that was the incident, I believe was in March of 21. I would have to go back and look for the exact date, but that is when the oldest child in the home and C went on a bus ride without mother's knowledge. In the immediate moment, mother discovered and then located C and the older child, I'm going to say J, in Boston. And mother went and retrieved them both and brought them back home. And at that, after coming back to the home, police coming to the house to visit, really to do a check to see that everyone was safe and sound. It was then, I believe, that Jay had an incident where her eyes rolled back on her head and she seemed to...
No, that's the marijuana. I think that Justice Hand is talking about a seizure that one of the younger children had, and it said somehow, I don't know.
Yes.
I was unaware this could happen, that Tylenol triggered it or something, or aspirin.
So it was in the record, and I can't remember the date, but yes, it was C, and that she had a seizure and she was taken to the hospital. And initially it was reported as, we don't know, mother was saying, I don't know. And then it was later, the record would suggest that mother divulged to, I believe it was the DCF social worker, I could be wrong, but divulged that C got into mother's pocketbook and got her Motrin, which that's all there is in the record.
There's no medical record about the seizure or diagnosis of a seizure or epilepsy or anything like that?
There was not, I didn't see that in the medical records. The medical records were primarily the mother's medical records, and then they were dental records for C and H. And I didn't see anything in the medical records relating to that. on that piece. I'm happy to answer more questions. I mean, I did address the mother's contention that, you know, the DCF didn't use reasonable efforts. And what I would just like to point out to the court is, it is in the transcript, that at the very beginning of this trial, the court offered, and DCF offered the mother the opportunity to stipulate to her unfitness, and then to avoid a termination of parental rights hearing. And that offer was made at least twice, and that's on page 8 of the transcript in volume 6, and on page 150 and 151. And obviously, they proceeded through 5 days of trial. And mother's testimony throughout that trial is that she was fit. That when asked, like, can you parent? Yes, why? She couldn't explain, but she was ready. You know, she had rest, she had time. She took the position that she was fit. She had the opportunity to be more reflective and to take that more time that she is arguing for now, and I would suggest that's an inconsistent position between trial and non-appeal.
Your time has expired. I do have one more question. When did you most recently speak with your clients?
So I most recently saw them back in the middle of January and spoke to them within the last, or spoke to the foster parents within the last week, both of them. In part, the goal was to visit them, but they were away on spring vacation and they flew in the homes. So, but I see them about every 6 to 8 weeks.
And do you speak with them directly or just observe them and
So
talk to the foster
directly.
parents?
My last visit was 2 hours with H, and the visit with C was about an hour and a half. And I have ample opportunity to have access to both foster parents, and they're doing well.
All right. Thank you all very much. Terrible. These are all terrible cases, but this is a particularly unfortunate circumstance. So thank you all very much. The case is submitted. Our final case of the morning is also an impounded case. We're not going to use names for the individual party and whatever else the scope of the impoundment order is. I assume counsel will know. It is John Doe, number 22661, versus Sex Offender Registry Board, number 231273.
Good morning, Your Honor. Your Honors. May it please the Court, Fred Burkholder, on behalf of Doe 22661. I apologize for not being ready. I thought we were, there was one more. My argument set forth in significant detail in the brief. I think this is a case where the hearing examiner spent a considerable period of time trying to evaluate the evidence, but came to the wrong conclusion. This is a case where my client has met the burden. The burden is to establish the existence of a nexus between a psychological condition, in this particular case, a psychological condition, and risk of reoffense.
Could I ask a question, Attorney Burkholder, with respect to the impact of the psychological condition on your client's initial offending? Am I understanding correctly that the clinical diagnosis he received, diagnoses, I guess, were after the first set of sexual offenses, but before subsequent
Yes,
offenses?
but not when my brother says they were. My brother says the first diagnosis of PTSD, of bipolar, was in '87. That's not what the record says. Both the hearing examiner as well as in the comprehensive evaluation, it's indicated that the first evaluation or the first diagnoses of that type occurred in the competency evaluation that was done on March 24th, 1983. And it's important that you bring that up because I want to just briefly read what the diagnosis was. Competency evaluation dated March 24th, 1983 recommended that Mr. did not suffer from a major mental illness, which the hearing examiner...
Could you not use the name, please?
What's that, please?
The name of the Doe's name.
Oh, yeah, I'm sorry.
Okay.
I know that I apologize. Yeah, I certainly apologize. So anyways, Doe did not suffer from a major mental illness, which the hearing examiner makes a great deal about. no diagnosis of major mental illness. But what about personality disorder? And I do a fair share of SDP cases. There's plenty of SDP findings based upon personality disorder. Studies clearly state that bipolar can establish a risk of reoffense. I don't even think my brother would argue about that. That said, the diagnosis at that time was severe personality disorder, a borderline personality disorder characterized by impulsivity, potentially self-damaging or other destructive behavior, substance abuse, and lack of control and anger. So my point is that way back from the very beginning, I mean, the first cluster of aggravated rapes occurred on 3/2/1983. This evaluation was within 3 weeks, 2 weeks. So I believe there's evidence that exists that he had a severe psychological condition that impacted it. Secondly, I think the hearing examiner acknowledges that the report from Dr. Humbridge, I shouldn't say Dr. Humbridge, from clinician Humbridge clearly says there's a correlation. But nonetheless, then goes into an analysis which frankly sounds more like a analysis of the adequacy of a report, potential report, and whether there's a objective, adequate reason to reject it. And my brother even cites a case which talks about the vast discretion that's afforded to the board based upon, that particular case was 209081, and that it shouldn't be disturbed. However,
could I just ask another question?
Yes.
Is what your client's looking for essentially someone else to say the same thing that, which I don't mean dismissively, it might make a difference, that the social worker Hambridge said?
Yes, but a little more. And the little more is this. This case really comes down to the following, in my opinion. Whether or not my client's actions were as a result of reacting to his upbringing and the physical abuse that he endured and the sexual abuse that he endured, or was the result of a pursuit of sexual gratification and deviance. I believe that through treatment, he's addressed what it would be if, in fact, there was a deviance that's involved. By all accounts, he's done very, very well. I've had similar cases where the issue was, is he going to stay on treatment? If he stays on treatment, he's fine. I mean, we can't lose sight of the fact that we're talking about offenses, and I understand what the guy did was horrendous, and I understand he got maximum sentences and the like, but it was 38 years ago. That's a long time ago. People change, and in this particular case, the guy has done everything he possibly could for himself. But for an expert or for a hearing examiner to say, well, even if it says that, I'm still going to dismiss and the like, how can you discard and not credit a report you haven't read? Because it doesn't exist.
But that's what I'm asking. Is the report that your client is looking for something different than what the social worker provided?
Yes.
Putting aside your issue of I appreciate the explanation that you provided about your client's argument about the conflation. But putting that aside, it's something different.
Well, certainly it would be more a development of the reduction in risk that occurs when he's compliant. I mean, what Humbert really says is there's a correlation and says specifically likely result in resentment. Let me see. As a result, I do believe that his risk of reoffense has lowered. I am happy to answer any questions you have. I want to know how far lowered. Are we talking about low risk? Are we talking about moderate risk? Are we talking about degree of only risk of reoffense? Are we talking about dangerousness as well? I mean, all the things that the ordinary psych evaluation report that we've all seen many, many times address. And that's not here. And if I had a report that said he's got a low risk, then I've got an argument to say, hey, 38 years have gone by, he's done nothing. I want to point out a couple other things that are at error in the analysis. One is that the first diagnosis not only didn't happen in 87, it happened in 83. Secondly, the hearing examiner makes quite a bit to do about the fact that there was no acting out throughout his incarceration. What they forget is he was charged on March 29th of 1995 with alleged sexual misconduct with a cellmate. So it's not like there was nothing there. And why that reference was made by the hearing examiner, who did a great job of reading through the rest of it, I think it was just picking and choosing what supported their argument. They didn't talk about personality disorder, although she mentions borderline personality disorder and kind of glosses over it. That's significant to me when you talk about lack of impulse control and the like. I stand on my brief unless there are any questions.
I see none. Thank you. Excellent argument as always.
Thank you, sir.
We will hear from you, Attorney Shanai.
Thank you. If it pleases the court, David Shanai for the board. The board's position is the hearing examiner came to the right conclusion, obviously. Otherwise, I wouldn't be here. The matter is that I think it's the amount of reports that were submitted. And I think the hearing examiner was basically saying, what more can be added to this record? And even if they came up with a conclusion based on looking at all the prior records that somehow the sex offending behavior was associated with his personality disorder, that wouldn't be dispositive of the case because there were other factors involved. More importantly, the hearing examiner under Factor 35 has the ability to consider these records, and they, according to the hearing examiner, they were pretty clear in the diagnoses and all the episodes this individual had over the years, and the fact that none of his episodes ever resulted in sexual misbehavior. And finally, the hearing examiner pointed out that this individual, although has been generally doing well, in 2020 did have a relapse mentally and had decompensation at that point, but again did not act out sexually, but keeping in mind that all of this is occurring within the incarceration system. He hasn't been in the community in over almost 40 years. He was still incarcerated.
The only question, I think, is funds for this expert.
Correct.
That's all we're figuring out.
Right.
I take it I read your brief, obviously, with some care. I take it your position is that there is no evidence linking his sex offending to mental illness. I mean, you just said none of the episode resulted in sexual misconduct, blah, blah, blah.
Correct.
And that the standard is if there is something linking his sex offending to mental illness, he gets an expert.
Correct.
So my question is just this. Why isn't the Hambridge letter evidence that his sex offending is linked to mental illness? She says there appears to be a correlation between his own history of trauma as a child and lack of appropriate treatment during crucial periods of his development, which likely resulted in a reliance on problematic sexual behaviors.
Correct.
So give him the funds and let him have a shrink figure out if that's right or not and what it might have to say in light of his treatment and everything else about risk of reoffense.
The thing is, that was in 2014, I believe. Contemporaneously with this individual, all of the reports and his sex offending behavior, there was never a mention.
It's 40 years ago. I don't know what they knew about mental health then.
Correct.
Right? I don't have any idea.
Well,
I was alive then, obviously, and, but, Duran was popular then. It's probably different now.
Well, I wasn't a big Duran fan, but I do remember
Duran. With their
Duran.
work, right?
I was more Eurythmics, but the reality is that the hearing examiners looked at this in three ways, really. One is that there was really no solid connection through the years that this individual's mental health was directly responsible for sex offending behavior.
She's not a doctor.
Well, no, she's going based on the reports that were listed that were used by the hearing exam or by the plaintiff to ask for funds, and the fact that earlier in his life it was either alcoholism they attributed to or hostility towards women. It wasn't until 2014 that even the idea that there may have been a connection to the mental health issues and his sex offending behavior which occurred 30 years earlier, was made by Dr. Ambridge. And again, the record's not clear where she came up with that connection.
Well, I don't know about that. It's a question of evidence, but I mean, I also have to say, and this is completely non-scientific and anecdotal, we didn't talk much about PTSD in 1983.
I beg to...
I'm not saying it didn't, like it wasn't sort of on the radar.
I think it was clearly on the radar because at that time they were dealing with Vietnam veterans. And I think that at that point that PTSD was in the lexicon of psychiatry.
Not in the lexicon, but it's obviously a, you know, it's viewed as much more widespread now, I think, than it was then.
But the question is, and I haven't run across one yet where PTSD was directly responsible for sex offending behavior. I've seen where it can be destructive behavior, but I haven't had a case yet where PTSD has been linked with actual sexual offending. And again, I do, you know, I've done
well, she doesn't really specify. She says lack of appropriate treatment.
Correct, and we're not sure what the treatment was actually for.
Better get a shrink to come look at it and tell us.
But that's, again, it was the onus was on the moving party to show that nexus, that it was much more. It's not, we should just get a psychiatrist to find out what a prior psychiatrist was talking about. It's,
well, she's a licensed social worker now.
A licensed social worker. There were so many reports in there, it's hard to remember who was a doctor and who was a licensed social worker. But I think that's essentially, I think my brief covers these arguments pretty well, and I always leave it to the court's discretion to make the appropriate decision in this matter. So unless there's any further questions.
No. All right, thank you very much. Great arguments as always by both of you. Thank you very much. The case is submitted, and that brings us to the conclusion of our sitting for today. I'd like to thank the court officers and the court staff for their excellent assistance as always, and we stand in recess.